May I request the speakers to please take seat.
Mr. Nitin Thakkar, President of the Bombay Bar Association, Mr. Naushad, the Engineer, Secretary of the Bombay Bar Association, ladies and gentlemen, welcome to the first ever AI Appreciation Day lecture. Before I begin, I'm going to request all of y'all to take out your phones and Google, when is AI Appreciation Day? Come on, fastest finger first. When is International AI Appreciation Day? I can't hear you. Perfect. Today. So this just proves two things. One is that we are not just making this up, it is genuinely AI Appreciation Day. And two, that all of us just use AI. So the reliance on AI is omnipresent, and whether we like it or not, it's a part of our daily lives. It's roaming around with us in our little phones. When I spoke to some of the junior colleagues at the bar about AI Appreciation Day, they were in fact very upset with me. They said, what is this? And I'm going to read out the things they told me. One, they said, AI gets no original ideas. Two, AI makes people dumb. Three, why should we appreciate something that we can't even rely on? Honestly, I had no answers. So now, I'm going to pass these questions on to my learned speakers today. And may I request Mr. Nitin Thakkar to kindly take the dais and tell us. Thank you. Can I have a big round of applause for him, please?
For her, not for me. AI is a subject with which all of us are grappling, will continue to grapple, because it is evolving. And I do not promise that my speech will have all the answers which Mahek has posed before us. So a very good evening to all of you. I want to start with my first day in court when I joined this profession in 1968. I had not envisioned a day when a command given to a machine would do work in minutes. In those days, our seniors would allow us to read their briefs, and we are quietly told, make a list of dates, and we would, at that time, in an interim application brief, we would make a list of dates on the back of a docket, and that was good enough. But now, when you watch a cricket match nowadays, there is an advertisement of a Chat GPT. And Chat GPT, the model is also a lawyer. And they are advertising how Chat GPT is useful to lawyers and in legal profession. And I think there are 4 or 5 things they say this Chat GPT will do. One of them is to make list of dates. So, really, in 68, I never imagined that this will happen. And today, we are in the middle of that age where a lot of things are part of machines, part of automation, part of somebody else doing our work quickly. I would only put it that way. So, when it was taking hours for a typewriter to do a thing, in that age, I have entered this profession. In 2016, when the Chief Justice of Supreme Court of United States of America, John Roberts, was asked, can you foresee a day when smart machines driven with artificial intelligences will assist with courtroom fact-finding, driven with artificial intelligences, will assist the courtroom fact-finding, or more controversially, even judicial decision-making? And he answered, it is a day that is here. So in America, the Chief Justice from 2016 is saying that that day is already there. But we find that some of the judicial functions are given to artificial intelligence in some American courts on a pilot project basis, like some traffic offenses and that kind of offenses. Still, the judging in murder trials is thankfully not given to artificial intelligence. Former Chief Justice of India, Dr. D.Y. Chandrachud, and his successors, Justice Gawai and Justice Suryakant, have consistently emphasized that technology must be harnessed to democratize access to justice, improve institutional efficiency, and reduce barriers to legal services, as it is not just an instrument of digitization. Excuse me, please don't stand there. Come and sit here. There are some empty chairs here. Please come and sit here. Please sit here. The chairs. Technological advancement has consistently led to the evolution of law and the profession, and advent of artificial intelligence is no different. Artificial intelligence is becoming an increasingly relevant development of considerable importance for lawyers and judges in the Indian system of incremental common law adjudication. The utilization of artificial intelligence by lawyers is surrounded by fierce deliberation with debate over whether to check this practice, promote it, or to regulate it among the legal fraternity. And I believe that is one of your questions. What should be done? The titans of our field did not build a career with, let us just ask ChatGPT. And I suggest that none of you go down that route. However, you must make the most of useful AI tools at your disposal. AI may or may not be the most remarkable invention of this century, but its tools certainly will transform the traditional practice of law. The story of artificial intelligence, of course, did not begin with ChatGPT. It began nearly 70 years ago in the summer of 1956 in Dartmouth College in the United States. Professor John McCarthy organized a research conference where the term artificial intelligence was first formally coined. At that time, AI was little more than an academic aspiration, a belief that one day machines might simulate aspects of human intelligence. Few could have imagined that within a lifetime, lawyers would routinely consult AI while preparing opinions, reviewing contracts, or researching constitutional questions. Today, generative AI systems are capable of drafting legal memoranda, summarizing thousands of pages of disclosure, comparing complex contractual provisions, translating legal documents into multiple languages, identifying inconsistencies in pleadings, predicting litigation trends, and assisting with due diligence exercises in a matter of seconds. The question, therefore, is no longer whether lawyers should engage with AI. The real question, however, is how lawyers should engage with AI. A study by McKinsey Global Institute determined that up to 44% of paralegal work and up to 22% of lawyer level work can be automated in the period up to 2030. AI powered tools can accelerate repetitive yet necessary tasks that often consume significant time. For example, drafting standard contracts, a process traditionally involving tedious cutting, pasting, deleting, and editing, can now be handled more quickly and accurately with AI assistance. And I believe on the next Thursday, we are going to have, not I believe, I am telling you, on next Thursday, we are going to have our 4 junior members of our bar, 2 from the legal firms and 2 counsel, who are going to tell us how they are using AI tools in their professional work. So I think, and they are going to demonstrate also how they are using it. So I am sure all of you will again turn up on the next Thursday. So AI tools can also support legal professionals in conducting faster research, reviewing precedents, and summarizing source material across platforms. They in turn will require legal professionals to make changes to their traditional business models. Shouldn't lawyers be as dynamic as law itself? No one who resists change can prosper in the long term. The Industrial Revolution transformed manufacturing. The Computer Revolution transformed commerce. The Internet Revolution transformed communication. Yet, history teaches us something reassuring. Technology has rarely replaced professions. It has replaced only those professionals who refuse to evolve. The greatest value of AI lies not in replacing legal thinking, but in freeing lawyers from repetitive tasks so that they may devote more time to what truly requires human intellect. Let us take a look at a few instances which help understand how AI has transformed legal work. In Argentina, for example, the virtual AI assist Prometea has helped legal professions process nearly 490 cases per month compared to just 130 before its introduction. This is almost a 300% increase in productivity. AI has been transforming how legal services deliver value to their clients. The International Bar Association, in its 2024 report on AI and legal profession, observed that AI has been widely adopted by law firms across the world, specifically for legal research, document drafting, due diligence, and administrative functions. At the same time, the report emphasizes that the effective use of AI requires continuous training and that the ultimate responsibility for all AI assisted work must always remain with the lawyer using. Based on the survey, 210 out of 333 people who responded were law firms that reported using AI in their operations. The responses indicate adoption of AI technology in private practice within the legal profession, with the majority of AI utilizing law firms located in Europe, including UK, the US, and operating in multiple jurisdictions through subsidiaries in different countries. Firms are using AI services such as Microsoft's Copilot and Azure. And our friends here of Lex Legis are also planning that more people use their AI software. This differs from client-facing uses such as legal research, document assembly, contract drafting, due diligence, and discovery for litigation cases. For these functions, generative AI, chatbots, e-diligence, and e-discovery platforms are being deployed. A study conducted by Reuters has found that 80% of the respondents believe AI will have a high or transformational impact on their work within the next 5 years, and 53% of respondents said their organizations are already seeing a return on investment from investing in AI. This tells us that lawyers with a multifaceted set of skills or versatility with AI will prove more valuable over ones not well equipped. In-house development of AI technology is found to be a significant competitive advantage for law firms as one of the most compelling benefits of AI that it saves time and boosts productivity. The American Bar Association reports widespread use of AI, and the report also says that Half of the largest firm, even as three-quarters of lawyers worried about the technology's accuracy, by far the greatest concern. Prosecutors, law enforcement officers, and court officials are increasingly using consumer chatbots to generate charging documents, case summaries, and legal research. If a survey is done in India, we may also have comparable statistics among youngsters and law firms. These statistics clearly indicate that AI is no longer a technology of the future, it has already become a part of everyday legal practice. When it comes to the use of AI by Indian judiciary, some tools have proved particularly helpful. In collaboration with NIC, Supreme Court is using SUVAS, Supreme Court Vidhik Anuvad software, an AI-driven translation tool of the Supreme Court, which converts judgments rendered in English and orders into vernacular languages, enhancing accessibility and regional language use in courts. These translated judgments are hosted on e-SCR portal, significantly expanding public access. One of the oldest high courts in India, Madras High Court, has introduced an AI-assisted system called Superlaw Courts, which functions as an intelligent record assistant, helping users locate and organize relevant information within case documents. It creates a secure digital workspace similar to a sealed judicial record room. This ensures confidentiality and controlled access to case materials. Adalat.ai, a speech-to-text tool adopted by Kerala High Court, automatically converts witness statements from speech into text in real time. Once recorded, they are uploaded to the district court case management system, where lawyers and parties can access them easily. This tool was developed under the Indian AI mission. The High Court of Delhi also utilizes Adalat AI, the machine learning system that lets judges dictate orders for automatic transcription and summary. Such active steps aim to relax the justice system from manual clerical work, freeing judges to focus more on adjudication to accelerate case delivery. The use of the artificial intelligence by lawyers to conduct legal research, however, appears to be a runaway trend. Notwithstanding the widespread reporting of several cases in which even highly regarded international law firms have been embarrassed by the filing of court submissions which have included fake citations or hallucinated quotations, lawyers continue to use artificial intelligence with reckless abandon to conduct legal research and fail to verify the AI-generated results. We have now become familiar with the phrase AI hallucination. It is perhaps one of the most misleadingly gentle expressions in modern technology. There is nothing illusory about its consequences. A hallucination occurs when an AI system confidently generates information that is entirely false, creating fictitious cases, misquoting judgments, inventing statutory provisions, or attributing observations to courts that were never made. Earlier this year, Justice B.V. Nagaratna, sitting with Chief Justice Suryakant and Justice Bagchi, while hearing a PIL, observed that lawyers had cited a non-existing judgment, Mercy versus Mankind. This is like having an Aadhaar card issued in the name of Hanumanji and all sorts of things which we have been reading in newspapers. And while citing the portions of the reported judgments which were quoted never existed in the original judgments. So our ladyship further stated that such instances not only undermine the credibility of legal submissions, but also place an unnecessary burden on courts to verify authorities. The bench also noted an alarming trend of lawyers using AI tools to draft petitions. Justice Bagchi referred to eminent lawyers as he spoke about the decline in the art of legal drafting with little articulation of legal grounds. A bench of Justice Narsiha and Justice Alok Aradhe held that reliance on hallucinated legal material strikes at the integrity of adjudication and its processes and directed courts to adopt a zero tolerance approach towards the production or use of AI generated precedents without proper verification. The bench also observed that it is a serious judicial lapse if a judge relies on such fabricated material while deciding a case. In fact, there is a judge in Punjab and Haryana High Court who decided a bail application relying on artificial intelligence. A judge in Madras court also did the same thing. Some of the judges of district judiciary have been relying on artificial intelligence to write judgments. And this has been brought to the notices of the Supreme Court in several matters, and that has prompted Supreme Court to now come up with a draft guidelines. I'm sure you are going to mention about draft guidelines of Supreme Court? No. But you can go on internet and find out that invited objections or suggestions. They're very comprehensive guidelines, and I think any movement now Supreme Court should adopt it and make it guidelines, sort of regulations which are permanently to be used. In Bombay High Court, Justice Sathe recently imposed a cost of rupees 50,000 on a litigant appearing as a party in person for submitting a non-existing judgment generated through AI, which the court and its clerks could not find, and thus deprecated such practice of dumping non-existing and irrelevant materials on the court and wasting precious judicial time. Justice Sathe recommended that AI tools used in aid of research are welcome. However, there is a great responsibility upon the party and advocates using such tools to cross-verify the references and make sure that the material generated is relevant and genuine and in existence. The Supreme Court recently stated that practice of citing AI-generated non-existent judgment is a menace which has been rampant not just in India but across the world. In approximately 50 court cases in which AI hallucinations have been considered, English courts have confirmed that any legal professional utilizing artificial intelligence tools bears a personal absolute duty to verify the accuracy of the output against the authoritative sources. Following two cases in which non-existent and inaccurate case authorities were put before the court, the English court has made it clear that failing to verify AI output amounts to professional negligence, which will likely warrant a regulatory referral and potentially vested cost orders, and where false material is deliberately placed before the court, a criminal investigation or contempt proceedings may be appropriate. American courts, we have seen the orders where they have ordered a lawyer to give a cost of $10,000 and they have been fined $10,000 and odd for using hallucinated material. South African High Court has also adopted a firm approach to the misuse of AI in legal practice. In two separate instances, the court dealt with pleadings containing AI-generated fictitious citations. Even the responses of counsel differed, where one denied using AI, whereas the other candidly admitted the mistake and apologized. Both matters were referred to the Legal Practice Council, like Bar Council. The message was unequivocal that the use of AI does not diminish a lawyer's professional responsibility to documents. The signature on the pleadings, however, will belong to the lawyer, not to the software. No court anywhere in the world has accepted the defense that the AI made the mistake, and no court should. In the regulations which Supreme Court has prescribed, as far as I recollect, They have said that you have to, the lawyer using AI in any court drafted documents submitted to court must give a certificate that I have used it, in which AI tool he has used it. And Supreme Court, I think, is going to prescribe limited tools. Only you can use only 1, 2, 3. They are going to, I think they've invited tender for that, and they are going to decide which tool they should allow them to use. And then a lawyer has to certify, so he has to put the signature that he owns the responsibility for whatever AI material in terms of SLP, in terms of written arguments or written submissions which are filed. So he has to own up the responsibility. So like with any technological innovation, the potential for hacking proposes a substantial risk. This is particularly important when concerned with legal matters. Although the systems presently do not involve high-stakes cases such as criminal trials, these tools have been potentially to save or ruin lives, build or cripple companies, and set incredibly significant social risks whose effects flow on for centuries. The world has already seen the impact of hacking into other branches of government through cases like electoral interference, and more technological integration into legal system is an invitation for vulnerability. Hence, innovators must grapple with these concerns. Generative AI can now instantly produce documents that closely resemble these legal artifacts. What looks like dozens of hours of work can be done in seconds. Interestingly, if one reads the guidance issued across jurisdictions from India, England, Wales, the United States, Canada, Australia, UNESCO, and even professional bodies such as the Quebec Bar and Bombay Bar Association, there is a striking convergence. Although each jurisdiction approaches regulation differently, almost all of them revolve around 5 enduring principles. Please remember FACTA, which you are required to do for your KYC with banks. Same initials, FACTA, are for fairness, accuracy, confidentiality, transparency, and accountability. So all guidelines will have these 5 as an essence. We know that court filings have been found increasingly to include AI's law. The problem is simple enough to demonstrate. If you give a news report to Claude or ChatGPT and ask them to draft a charging memorandum, you will find that each of the documents is fluent and professionally formatted, citing statutes from the state in which the event occurred, but the charging decisions the chatbots reach may well be different. One may recommend attempted murder, the other aggravated assault. Each will likely also fabricate facts, for example, referencing body camera footage when only a dashboard camera was present and describing the suspect as visible when he was not. But what if someday better models could produce more accurate and reliable results? The focus on mistakes as the main problem at stake distracts us from a deeper question, particularly in prosecution. AI cannot replace human judgment. AI does not apply statutes, weigh precedents, or enforce official standards. It produces no audit trail showing which authorities govern its conclusions. AI attempts to replicate aspects of human reasoning itself. It drafts, it summarizes, it predicts, it translates, it analyzes, it converses, and because it appears to think, it creates an illusion that it understands. That illusion is precisely why our profession must approach it with both curiosity and caution. The dangers associated with solely relying on AI are hence not to be overlooked, as if there is one lesson that the legal profession has learned over centuries. It is that every powerful innovation carries with it an equally powerful responsibility. While AI models may operate in a manner that may be statistically accurate, they are jurisprudentially unjust. AI systems are trained on existing data and patterns which may inadvertently favor certain interpretations, authorities, or arguments while overlooking others. In legal drafting, such omissions can have serious consequences. A minor point that the AI fails to identify may in fact prove decisive to the pleadings and subsequently the outcome of the case. Like the first notice a lawyer gives, if it overlooks a legal provision and turns out to be defective, may decide fate of the suit ultimately. This is precisely why an advocate's independent analysis and professional judgment remain indispensable. We, who belong to the older generation, had the privilege of standing before this court and remember our early years at the bar. We learned advocacy by not reading about it, but by living it. Spent endless days in court observing seniors, spent evenings in libraries. We drafted and redrafted pleadings. We carried heavy briefs. Today we only carry one laptop. Attended conferences with our seniors. We learned not merely what the law was, but how lawyers think. Those experiences were never incidental. They were our education. Technology should accelerate learning, but never replace it. As a member of the bar, we owe a responsibility not only to our clients, but also to those who will inherit this profession after us. They must learn to use artificial intelligence, but they must first learn to think like lawyers. Only then will technology become an asset rather than a crutch. As I conclude, I acknowledge that AI has improved legal research. It equips advocates to locate authorities and precedents in minutes instead of hours. However, the recent instances of fabricated citations remind us that AI-generated research cannot replace independent verification. Therefore, AI should remain an aid rather than the source of legal judgment. Technology must be the servant of justice and not its master. Indeed, one might say that artificial intelligence offers us an opportunity to become better lawyers, provided we resist the temptation to become lazy lawyers. The responsibility for every argument, research, and opinion should therefore be that of the lawyer. In lighter vein, AI undoubtedly possesses many admirable qualities. It never complains of late nights. It never seeks an adjournment. It never objects to working through weekends. It never asks for an increase in professional fees. Unfortunately, it also has one rather inconvenient habit. Every now and then, it invents the law. Justice Suryakant, the Honorable Chief Justice of India, believes that justice, unlike software, is not a product to be optimized, but a principle to be honored. Thus, justice cannot be programmed. It must be pursued. Let us not merely adapt to AI, let us lead it. Let us not be dazzled by its capabilities, but deliberate its consequences. And above all, let us reaffirm that even in the age of machines, it is a human conscience that must speak the last word. That is why the draft regulations proposed by Supreme Court of India emphasize human primacy. Use of artificial intelligence must therefore be regulated to ensure that it does not replace human function. Instead, it must serve only as an aid to humans to carry out clerical or administrative tasks which could be done quickly and improve quality of service. The Bombay Bar Association has for over a century stood as one of the guardians of the finest traditions of the legal profession. Those traditions have never been defined by the tools we used. They have been defined by the values we uphold. Those values carried us through the transition from handwritten briefs to typewriters. They carried us through the advent of computers. They carried us through digitization, e-filing, and virtual courts. They will carry us through the age of artificial intelligence and as well. Because the foundation of this profession has never been technology, it has always been character. Paragraph 2 and page 4 of our guidelines is a testament to our adaptivity with the evolving times. Thank you very much. And I hope I have answered your question.
Thank you, Mr. Thakkar. I think one of the most interesting questions that he asked is, the question is not whether lawyers should engage with AI, but it is how lawyers should engage with AI. And I think that is the core question, which will be answered also next week, and also with the help of my learned senior, Mr. Naushad, the engineer. Can I please have a big round of applause for him?
Thank you, Mehak. Thank you, Nitin Bhai. Good evening, everyone. I'll try to keep this as short and as painless as possible. Can I just ask everyone who's tried to use AI, would you put your hand up? Everyone except the first row.
I have used it once, only to find out the answer whether lawyers should use AI for which I always speak in that advocacy training.
So, as Mehak started by saying that it's not a coincidence that the BBA has chosen 16th July to start its lecture series on artificial intelligence. Today is National AI Day, but it's National AI Day only in the US of A. But I guess as what happens in the West is often repeated over here, I can only tell you that there was a huge lecture series which actually took place just now even in Delhi, in which judges of the Supreme Court of various jurisdictions also went. There were judges from our court who also were there in Delhi on the 11th of July. And the discussion there also was on the use of AI in the legal profession. I personally believe that should we use AI is no longer a question. The answer has to be yes. And what is AI in that sense is, it is nothing but a new technology. All of those sitting in the first row will remember that when they started their professions, as when I did, there was nothing like Manupatra, there was nothing like SCC Online. When your senior asked you for a judgment, you were scurrying around in the library, clicking your fingers and asking, at that time Jairam, who used to be in the library, to get you a case citator, get you commentaries, pull out the actual judgments. You read it, you noted it down, and then there was the fight to see whether you could push your book higher up in the Xerox line to try and get the Xerox so that your senior would have the judgment, otherwise, he'd have you for lunch. So then came SCC. SCC Online is something that I think most of y'all, even all the young ones, have grown up on. And SCC Online was an advancement in technology because you now didn't have to actually go and read through the books, and you didn't have to look at digests to try and figure out. You could key in words. And SCC Online was an advancement in technology because you could put in words, and from a defined database, the computer was going to identify which judgments had those words that you keyed in. Sort of like an artificial intelligence, if you would say. It's not really AI because it's actually just a word search program. The next step now is artificial intelligence, and it really is not any form of intelligence actually. And what we've done is, we were first thinking, do we have this program over one day, and we found that it would just take too much time, so we've broken it up. Nitin Bhai has just told you all in that sense a general overview of AI, the problems that it faces. I'm going to basically touch upon and amplify why these problems arise and how best to try and avoid these problems. And on the next occasion, we're actually going to show you all, with the help of juniors from our bar who have extensively studied AI, figured out how to use AI, to use it in a way where AI no longer even gives hallucinations for the most part. So, and then of course we have technical experts who will also be coming in and will be actually showcasing their products for you to actually consider. So, if we actually look at AI, as I've said, it's technology. And the whole object of technology is actually to make your life easier. So, today when we use AI, it would be wonderful if you could just key in a question and the most detailed, technically proficient and accurate answer comes out. Now that presupposes that the computer actually has a brain, that the computer somehow understands what you are asking and in its infinite wisdom will give you a complete answer. And it is with that reliance that idiots like me would use AI. And when you use AI in that manner, you're bound to get wrong answers. Because AI doesn't understand what you're saying. It only recognizes characters that you're putting together. It recognizes those characters as words. And it basically recognizes patterns. All these AI programs are known as large language modules. They only actually recognize pattern in words. They actually have no intelligence. They don't know what is right. They don't know what is wrong. Which is why when you ask a question such as, give me a citation of a judgment which holds that unliquidated damages cannot be secured at an interim stage, it will actually know that, oh, if the word citation is there, there are going to be numbers of a year, a volume, and a page number. It will then say that there has to be a name to this citation. And it will just simply collect what it thinks is the most probable or predictable answer. It obviously goes through its database to actually see what's available. But the other aspect which you need to realize is AI is always programmed to give you an answer. Unlike a good junior who, when you ask it a question, and if the junior doesn't know, he'll probably tell you, I don't know. AI will never tell you, I don't know. AI will always give you an answer, right or wrong. It will give you whatever it thinks is the most predictable thing it should say to answer your question. So it is this problem in AI that really needs to be resolved. And like all technology, today it is at its most nascent stage. Like all technology, it will develop, it will adapt, and it will improve. If it doesn't, I don't see AI then really being the future that everyone thinks that it might be. But like all technology, it will adapt and it will improve, and you will find a far greater accuracy. I don't know, I've been using AI for a bit just now, and I do find that today when I key in questions also, it actually now, and it's the way that you put in what are called the prompts or the guidelines that you give AI sometimes will actually tell me, I'm not sure about this answer, I suggest that you actually check this judgment to see if it says what I'm telling you it says. So there are times when AI will actually quote the judgment to you. Because AI, the other thing that you all must remember is, AI only has access to information that is freely available on the internet. So AI cannot access SEC online. It cannot access any case law database, because to access that it needs a paid subscription. Now AI does not have a paid subscription to SEC online, unless whether you say whether it be ChatGPT or Claude. If, for example, they were to actually subscribe to that and then say that we have our own subscription and therefore we are going to be able to access these authentic databases, perhaps then yes, but today that's not how it works. Commercially, I don't think it would make sense for the AI companies to actually do that also. So when we think about these shortcomings of AI, one, it does not know what is the truth. It does not know what is false. It cannot tell you what is accurate and correct. Two, AI, as I said, is programmed to give you an answer. So it will give you an answer, irrespective of whether it's correct or not. Three, and this is important for those especially who use AI for the purpose of making your list of dates. We somehow believe that AI has got some infinite amount of memory and infinite wisdom. AI actually operates on something that is known as a context window. And everything that I'm telling you today is thanks to one of my juniors who's sitting at the back, who's really done a lot of research on AI and explained this to me. And in fact, he will also be speaking to you all later and actually demonstrating how to use AI. So AI has what is known as a context window. And each context window is the amount of information that it can hold at a particular time. And the amount of that window is counted in what is called tokens. Tokens effectively is one word is one token, roughly. And when you actually, and you all can check this out yourselves when you all ask ChatGPT, what is your context window? Or ask Claude, or ask Gemini, or whatever it is, what is your context window? The free versions have a small context window, maybe only of 100,000, which literally means that after 100,000 words, AI is not recognizing anything. It can't remember anything. So when you have 100,000 words, maybe a small book. Now when you have a brief of maybe say 10,000 pages or 20,000 pages in large, say, construction arbitration, and you basically put that whole brief into an AI module and say, give me a list of dates of everything. After that 100,000 your context window, AI has lost the ability to think. So if you think that AI is gone and given everything to you, you're completely wrong. Now, of course, context windows are also increasing with each new, as you know, say like for Claude, first had maybe the Opus 4, then Opus 4.6, 4.7, so it keeps increasing it. The paid versions naturally, obviously, have much larger context windows. So you have to be very careful in this for those of you all who are using AI for drafting list of dates. Please note that AI is not looking at everything in that 10,000 page brief. It's just selecting what it thinks is relevant. So this aspect of memory, AI does not have infinite memory. And like all commercial products, AI is also programmed to give you an answer in the most economical way for the program. What that basically means is that if today I as a senior ask my junior, I want a judgment on this proposition, the junior will look through. The minute he finds the first head note, he'll say, sir, this is it, this is the answer. He's not actually bothered to maybe even read the judgment. He's not bothered to check whether that judgment has been overruled. He's not bothered to check whether there are other judgments of other courts that have taken inconsistent views. So AI works in the most economical way for itself. It's not actually sitting there and applying its mind and trying to give you the most complete answer. So these are things that all of you all need to bear in mind when you all are using AI. So these really are its shortcomings. And as Nitin Bhai has already pointed out, there are many mistakes. When I was sitting hearing Nitin Bhai, I just Googled, I said, how many cases globally have been reported where AI hallucinations have taken place? And right now it's around about 1,750 odd cases where AI has been used. And I'm not going to repeat them. We all know about Mercy versus Mankind and all these judgments. Very recently, in fact, in Quebec, in Canada, there were decisions by the judges themselves where they had prepared their decisions only using AI. The AI decisions had actually cited judgments that never existed. The judges initially tried to say, no, this was cited by the parties, but the parties said, no, this was never cited by us. And in fact, then strictures have been passed against these judges. Awards have been set aside because awards have been drafted. Written submissions of both sides are taken by the arbitrator. The arbitrator simply says, the claimant's claim is this, respondent's claim is this is the claimant's submission, this is the respondent's submission. Please draft an award in accordance with law. And the award comes out with something which is maybe even quoting things, putting in clauses of contracts that don't exist because AI somehow found some clause of a contract when it was just sort of skimming through the net. So if you are doing this, or if anyone is using AI, you cannot use it as on date in a way where you don't verify the work or the product that actually comes out. And that's the only negative right now, is that you cannot rely on that product. And mostly it's also because of the way we ask the questions. So this is obviously in that sense where it goes wrong. Now what happens if it goes wrong? Our courts now are basically, and they're taking a slightly stricter view. As you know, Section 35 of our Advocates Act, and it's, I think, Chapter 10 of our Bar Council rules. If you are misquoting judgments and relying upon this, it is a statement that you as an officer of the court are making to the court. It can entail Bar Council proceedings against you. It can entail your disbarment. It can entail dismissal of the case. It can entail monetary costs being imposed on you as an advocate. And I think the worst of all is the reputational damage you sustain. Because the minute a judge believes that here's a lawyer who hasn't even bothered to check the work. I mean, if today any of us who are, if a junior was to just give a draft of the submissions and we simply say, all right, fine, done, I'm not even going to look at it, and if it's wrong, you are responsible. AI is like that junior. You have to look at the work that comes out from AI. You cannot just simply say, okay, this is done. In fact, in that first case of Mata versus Avianca, there was an American lawyer, I believe his name was Stephen Schwartz. He was at the bar for more than 30 years. And he filed submissions only using AI. He basically put the plaint in and said, draft submissions. And he got these submissions, and the submissions which were tendered to court had all sorts of fictitious rules being relied upon and fictitious judgments. And when the court asked him and said, okay, didn't you even bother to check? He said, how do I know that a machine is going to invent and make up things? And he said, I can't be blamed because it's not my work product, it's the machine's work product. To which, of course, the court said that no, as a lawyer, you are responsible for anything that you tender under your signature and under your, in our case, and under our vakalatnama, which we tender to the courts. So this is really where we need to be careful, because the last thing we ever want to do is give an impression to a judge that I'm somebody who is careless, that I'm somebody who's not fact-checking every aspect, every date, every page number. Now, this actually leads to, I think, what is the most important, and sorry, one last thing. The other negative aspect when it comes to AI, which may not be so much, say, for litigating lawyers, but far more for transactional lawyers, is confidentiality. What your client tells you is obviously confidential. Nobody can ask you to disclose it. But the minute you put onto a public AI platform information which is otherwise confidential, it ceases to be confidential information. And in fact, clients who may disclose things to their lawyers, expecting that none of this will ever get out, once it is put into AI, in America, the courts have held that this ceases to be confidential information. And in fact, authorities can look into it. They can compel lawyers to actually go and give evidence against their own clients on this aspect. So again, something which you need to be very careful of, which is why today I know in America, even in India, a lot of the larger firms are actually now creating in-house AI models, whereby the information is still stored on their own private servers and doesn't go out into the public domain. But not all of us have that facility. So if you are using AI, please make sure, if it is confidential information, if it is something that your client does not want to be known into the public domain, you cannot upload that into AI. It ceases to be confidential, and it's otherwise amounts to breach of its professional negligence on our part, and its breach of trust and faith for the client. So this really is the negative aspect, but like I said, there's no question, and Nitin Bhai also said the same thing. This is not a case of do I use it, do I not use it. According to me, the answer has to be yes, it has to be used. and the only thing we need to know is how to use it. And I mean, just as an analogy, doctors earlier performed surgeries maybe only by physically examining a patient. Then came the X-ray, then came the CT scan, and then came the MRI. Today, if a doctor was to operate on you without making you undergo a CT or an MRI, and then when he opens you up and he says, oh, I didn't know it was like this, it was like that, you would actually sue the doctor for not using the technology in the way he should. I'm certain that a time will be there when even for lawyers, a client may sue a lawyer saying, you had AI, you could have asked these questions to AI, you didn't even exercise that basic bit. So today when lawyers may be subjected to professional negligence suits for using AI in the wrong way, there may be a time when AI becomes so proficient that lawyers who choose not to use AI may be sued for negligence. So it's something that we all need to learn. And according to me, at least from a litigating lawyer's point of view, and say as a counsel, where I want to use AI, AI can be used in many things. One, as they said, drafting of contracts, drafting of agreements, preparation of list of dates, preparation of pleadings, preparation of written submissions, and research. I use AI mostly for research, and I think that it's where we can actually use technology in the most effective way. Because what's the most time-consuming thing that we all face as litigating lawyers is the amount of time we spend on research. We're constantly saying, no, this judgment isn't good enough, find something else, find something else. So if this technology can help us in saving time, research that may have taken 6 hours using books, today we can do in 1 hour using SCC. Perhaps it'll be 5 minutes using AI. But we then need to know how to give those correct prompts. Now, I'm not the expert, and on the next occasion, you will actually see demonstrations of how AI is used giving a general prompt versus a specific prompt. But what I would suggest is this. There are basically 4 or 5 elements that you need to keep in mind whenever you are giving a prompt. A prompt basically is what you are asking AI to do. So you need to, and this is it. One is you need to assign a role. So you need to you can't just ask AI, tell me about this. You have to first actually say, you are a senior advocate, or you are a senior partner in a law firm having 50 years of experience, and you have dealt extensively with cases relating to so-and-so. So you are actually telling AI what role he is to assume. 2 is you have to then identify the task. If you were to go and tell, as you were to tell anyone, give me an overview of the Contract Act. Now, if you were to ask that to a junior, the junior wouldn't know what exactly you want. So the junior may say the Contract Act was drafted in this year. The Contract Act deals with contractual relations between parties. The Contract Act has so many sections. But if you tell a junior, I want you to give me a note on the Contract Act, tell me how many chapters there are, tell me the headings of each chapter, tell me briefly what each chapter deals with, and give me the 5 most common judgments relating to formation of contract. Then you have given a guideline and an instruction to the junior, so the junior knows what's expected of him. It's the exact same thing with AI. So if you give a vague query to AI, you will get a vague, nondescript answer. If you give a specific query and you give a specific task to AI, you will get that specific answer. You have to instruct AI everything. It's actually not intelligent. You have to tell AI, you will only look at verified sources like Indian Qanun or Case Mine or any of these other free apps. So go log into the Bombay High Court website, look at the cases that are publicly available, only give verified decisions. If you do not know something, please tell me you do not know it. You can actually put these type of instructions into AI. Tell AI that every judgment, I want judgments only after the year so-and-so. Please, or you can tell AI, show me judgments pre-amendment and post-amendment. And when you get answers, you can then keep refining further and further and further questions to actually see. And a very good thing to do to AI is when AI gives you an answer, ask AI, is there a contradictory view? Do you think that this view is correct? And often you will find AI will say that these are judgments, however, in another judgment, this was held to the opposite. So be specific in your task. Third is context. You must, and it takes time. Don't think that the prompt that you give is a prompt which is going to be 2 lines or 3 lines. Maybe spend 10 minutes in your prompt itself. Give context. Explain to AI why you are asking it. What are the basic facts also of why you are asking it? Give a background of your case, and then ask the question, and then ask the task, and then give the directions of where it is to actually look. If you do all this, you will actually get an answer which is structured. You will be amazed. In fact, my junior Viraj, he's sitting at the back. He has created prompts by which actually you get instruction. You'll get a table of judgments. Each judge, it will actually tell you whether the judgment has been overruled, where it's been relied upon, and everything. It all comes down, but it's because his prompt is probably 3.5 pages long. But he spends that time, he's invested that time into making that prompt so that when the judgment comes out, rather the note comes out from AI, it has no hallucinations. It will tell you where you will find the judgment. It will actually tell you where the circulars are there, etc., etc. And you can actually rely on it. And as I said, the other aspect is to layer your questions. So you can ask one question. When you get the answer, you then refine it by asking a further question and a further question and a further question till you actually get to that specific point that you want. For example, you could ask, what is the law relating to damages under the Indian Contract Act? Then it will tell you section 72, 73, 74. Then you will say, what is the difference between 73 and 74? Then it will tell you that. Then say, which are the leading judgments under 73? Which are the leading judgments under 74 of the Supreme Court of India from this period to this period, or whatever it is. And that way you will actually get far more accurate answers. So, this of course is something which on the next occasion you all will see, that when you put in a general prompt versus a specific prompt, how the answers actually change, how you can avoid hallucinations, and how you can get a work product which is something that you won't have to keep fact-checking all the time. I'll tell you a very interesting thing which I heard. This happened just now. A federal court judge in Malaysia, while speaking in New Delhi on the 11th of July, said that the judges over there, when they decide a criminal murder case, they obviously appreciate the evidence themselves, they read and they come to the conclusion themselves, and then they decide that yes, this person has committed the murder. But for sentencing, what they do is they rely on AI for sentencing. What they said is that because each person has their own bias, I may think that what this person did is just shocking. Somebody else may feel, oh, there was some more extenuating circumstances. Third person may say, this person deserves the death penalty. Somebody may be entirely opposed to the death penalty. So what's then happening is everybody has their own personal, I would not want to use the word bias, but has their own personal take on matters, or what Justice M.C. Chagla called the inarticulate major premise of the man. So what they do is, to ensure that there is a far more standard sentencing procedure, they actually take their decision holding the person guilty, and they take their decision without any punishment being imposed, and they upload it into AI. They have their entire case, so every judgment of the court is available. And they say that as per these facts, what is the most common punishment that would be imposed considering all these factors? And then AI actually gives them the average to say, well, in most of these cases, or in these type of cases, 72 times the court has said 6 years in jail, 22 times the court has said life in jail, 5 times the death penalty has been imposed. So then the judge actually has the ability to figure out what is the court normally doing. And apparently not a single decision of that federal court has been overturned on disproportionate punishment. So it's an example of how the judiciary is using AI in a good way to actually cut out what some might consider to be bias, some might consider to be, predilections of a person. So I don't want to really take up much more time, but this is, in that sense, my 2 cents on AI. It's something that all of us should get to know how to use correctly. And I do hope that all of you all come for the next lecture where you'll actually be given examples of how to give these correct prompts to ensure that the shortfalls of AI can be avoided. So, thank you so much.
Thank you, Mr. Engineer. I think one thing we established that when he said I'm not an AI expert, he was definitely lying to all of us because he's used words that we've never heard of, like tokens, context window. No, prompts I've heard, yeah, but thank you, that was enlightening. And in fact, when Mr. Engineer spoke about in-house AI models, and since he was also discussing about how next week there are going to be actual live demonstrations on how to use AI, 2 of the panelists are in fact from law firms where they have the in-house models. So your questions could be addressed to them at that point if there are any. But before I send everyone off for a cup of tea, are there any questions that you have for this, the leaders of our bar? And nothing too complicated, please. They are genuinely not experts. So I wasn't lying. Any questions? Yes. Just 1 second. I'll just give you the mic.
Nitin sir, thank you for your speech. In your speech, you mentioned right at the beginning that you started off your career preparing a list of dates at the back of a docket. And I'm sure that many others also, carried out similar activities. Now, my question is today, if we use AI, not maybe for research, but for something that we would consider a routine task like preparing a list of dates, do you feel that there's a certain skill set that people of our generation would be missing out on by maybe not putting in the time and effort? Because every time you make a list of dates, it basically means you're going through the entire brief to prepare that. And when you try to optimize your process by using AI for preparing that, it does tend to happen that you don't end up going through the entire brief and you maybe, skip over it and read just the summary or something like that. So do you believe that there's some way we can balance using it to optimize our work in such a manner that we don't miss out on doing the essential task of skill building?
I can tell you one thing. I worked with Mr. Fali Nariman. Mr. Nariman, whenever we would go for a conference, he would first say, where is your list of dates? Then he will suddenly ask one question from one of the dates. Now, if you have read your brief, you will be able to answer. So, merely asking machine to prepare list of dates, what you are going to miss out is that whether you have understood the matter. And that is very essential. What I would do is that even today as a youngster, I may not physically now prepare list of dates, but I will read my brief and then put that brief into machine. Now you prepare list of dates. Because either judge asks you a question, your senior asks you a question, you should be able to answer it. Merely asking machine to prepare list of dates, giving it to judge, and now you read and you decide the matter. There is a lazy advocate.
Lazy.
Sorry, just if I could add to that. There are some tasks which you cannot, in that sense, assign away. As in, even say as a senior, I know some people say seniors don't read, but most still do.
Seniors don't read whole brief, but they know what to read in the brief.
Yeah. But in the sense that...
I don't advise everybody to do that. When you are in that stage, you do that.
But it still is, because what happens is when you are reading, AI still will just factually read things. There are things which you, as the lawyer, when you read a letter, will be able to think of, which sometimes put a slant on some words or which can put a slant on a letter, which the machine will not be able to do. So perhaps if you just wanted as a first draft to say, all right, list out every single date that is mentioned in this brief, chronologically, then that's fine. But if you were to say that, okay, this is the list of dates, I'm relying upon it only for that purpose, and this is it, I'm not going to bother reading myself, no. Then that's not how to use AI. I'd said it once in another talk, that so long as you are using AI to augment your intelligence, so AI should actually stand for augmented intelligence rather than artificial or some sort of alternate intelligence, it's fine. But if you are using it in a way that you are not going to apply your mind, then clearly you're missing the point.
Thank you. The next question there. You hold on to your mic. I'll give this mic.
You wanted to ask a question.
Yes. Yeah. One sec. We'll give you the mic.
Hello.
Sorry, one sec.
There is someone behind you. Sorry.
I have a question. In today's age, whether lawyers should focus on prompt engineering, because already I think we have passed away the prompt engineering stage. Today we are in the age of agentic AI, and more precisely in AGI. So we really need to focus on prompts to ask AI to give some answers.
So yes, agents and how to use agents is obviously the way forward. It is now what is being developed, especially in more of the pro versions of Claude, etc., etc. But you still sometimes will need to use prompts, because if you want to give a very specific type of instruction, it is something that you still need to know how to do. It's like even still today, as we said, in the age of artificial intelligence, nothing is ever going to beat your ability to read your own brief, because when you're standing before the judge and the judge asks you a question, you can't tell the judge, wait, I'm going to ask AI. So it still has to be here.
Yeah. Last question.
Hello. I'm an AI developer. I personally develop systems. I'm a consultant, specialist. Well, there's a paradox that I wish to bring to your notice. It's not a question. It's just something which I wish to bring to your notice. As per my experience developing these systems, we are talking about artificial intelligence. We are speaking about artificial intelligence. It's a hype. It's an ongoing hype. Actually, geopolitically, it is a weapons used by states to get maximum advantage in this age. Unfortunately for our country, we have got a lot of intellectual prowess, people, very capable people, very talented people. But unfortunately, we do not have an AI model. You understand? Now the other day, Mythos was pulled back by Anthropic. Mythos was a model that was introduced by the American company, and due to security reasons, it was pulled off. Lot of companies suffered a lot of economic loss, especially TCS. They had signed up 50,000 units of Anthropic Mythos, but that never happened. Without having a model, developing applications, creating prompts, agentic structures, it's not going to get you anywhere. Tomorrow, if the Chinese GLM 5.2 or Anthropic Claude or GPT 5.6 or any of this Kimi 2.7, if they start saying, we are not going to give you our software, we are not going to give you our model, what will you do? What will your application work on? We are hyping this thing. It shouldn't be. Without having an indigenous sovereign model in this country, we should refrain ourselves because tomorrow things can go wrong.
Thank you, sir, for your opinion. Do I have one more question, please, Mr. Thakkar, since this... Yes. Is that a question? Is that
not a question.
I'm sorry to interrupt you. We're open for questions. Any other discussion?
No,
Let's just keep it...
I just want to add something
Sure.
on the esteemed panel, whatever was said, because today being AI and we are following AI Day as per the US, the mandate is from this year. They have started a new paper called Media Content, and I'm sure India and other countries will follow that. And all these questions that we are now discussing, because it's at the initial stage and we are still in evolving and developing stage. I'm doing my research in AI, that's the reason I'm streamlining it. So just wanted to bring that also to the addition of your esteemed, whatever findings and
Thank you so
enlightening
much.
experience.
Thank you.
Thank you. I'm sorry, but Mr. Deshmukh actually has a genuine question that he'd like to ask you. If you could just indulge me for one last question. Any other questions or discussions? Once everyone's broken for tea, please feel free to speak to us, yes? Just one last question by Mr. Deshmukh, please. Wait for a mic. Mr. Engineer.
My question is to Mr. Engineer. You spoke about using AI for research-based work in our profession. What is the difference in the approach in how you do research on SCC Online and AI? Because ultimately, even for SCC Online, you would be using certain prompts, Boolean search, etc., which would get you the judgment what you want. So how is that different from what you would do research in?
When you are using, I'm not saying AI SCC, I'm saying the old traditional SCC. You could never ask a question to it. You had to only basically say that either you search topic-wise, or you searched, say if you knew who the judge was, you'd search judge-wise. If you knew the year or the citation, you could put that in. Or if you wanted certain words which were there in a judgment, I'm going back to the same example, say securing claim unliquidated damages interim stage. So you would just put those words in because you wanted a judgment that dealt with that topic. You weren't asking a question. You were only telling SCC, please from your database, give me the results where these words are found in the judgment. And you could choose whether the words were in the head note or in the full text. So you were not able to ask a question. To AI, you can ask a question. You can say, if a company is and I've done this, if I'm giving this example, if a company is constructing its own oil pipeline and that pipeline runs through BPT lands, can BPT charge service tax? Now, if I was to put that into SCC, only wherever BPT would be there would come up, wherever oil, pipeline, service, tax, everything would come up. It's not answering my question, it's only just looking for the words. It's a word search program. Here what's happening is it's actually trying to answer your question by predicting what the answer would be. It's not just looking for those very same words, it is actually trying to answer your question. So it may actually say that there is a circular issued by the Ministry of Petroleum and Natural Gas, and this is actually what happened. There was a matter where I was appointed as an amicus to answer this very same question. And I said, okay, I mean, this is something different, I don't know the answer. So I put it into ChatGPT. ChatGPT gave me an answer saying, yes, it is liable to service tax. This is pursuant to a circular issued by the Ministry of Petroleum and Natural Gas, circular number, circular date, everything was there. I got this and I very proudly walked out to my juniors. I very proudly walked and I asked my juniors and my juniors said, sir, we've not found anything. I walked out, I said, ha ha ha, here's the circular, none of you all could find it. So then I told them, I said, pull out the circular. Circular didn't exist.
On that note, I think we've had a wonderful session and you all have been a wonderful audience. Please join us for a cup of tea and can I have a big round of applause for our speakers, please?
For them, for coming.